Can property be divided after a marriage annulment? Imagine a marriage that never really was. That's what an annulment does. It says the marriage never legally existed from the start. So you might wonder what happens to property after that? Well, it's a bit different from a divorce. When a marriage is annulled, the law treats it as if it never happened. Because of this, there's usually no division of marital property like in a divorce. But property that was bought or acquired during the relationship might still be a different story. Courts look at who owns what based on records like receipts or titles. They don't split property equally like in a divorce. Instead, they decide who owns each item based on proof of ownership. For example, if one person bought a house or a car, they usually keep it unless the other can prove they contributed or have a claim. Some states, like Texas, allow courts to divide property fairly, even in annulment cases. They separate property into what was owned before the marriage and what was acquired during it. The court then makes a fair decision based on what's just. It's important to know that annulment usually doesn't involve spousal support or automatic property sharing. If one spouse bought a family home, the other might not have a claim unless they can show they contributed financially or have ownership rights. So, even though the marriage is considered void, property division can still happen based on ownership and fairness. The rules depend on state laws and the details of each case. If you're thinking about an annulment, it's smart to gather proof of what you own. Remember, property isn't automatically split like in divorce cases. It's all about what's fair and who owns what. This means you might need to show receipts, titles, or other proof to support your claim. Understanding these rules can help you navigate property issues during an annulment. Always check your state's laws or talk to a family law professional to see how property might be divided in your situation.